Good morning, friends. Welcome to the last session of our series on PIT regulation and code of conduct. And we have with us today the veteran, our friend Rajendra Singhi from ITC to share his experience. Today's presentation will be done by one of our partner, Kanchan Sharma. And of course, our all-rounder, Mr. Bala, is always there. Just for the disappointment of participant, today Mr. Sudhakar is not there because he has some family emergency and he excused us and requested all of you apology. But yes, we have with us Mr. Bala and Mr. Rajendra. And of course, you all are, itself our audience is very intelligent and very participative. So let's start today's our sharing of knowledge session on PIT regulation, Code of Conduct and Compliance under PIT regulation 2015. And just to formally introduce Mr. Rajendra Singhi. Mr. Rajendra Singhi is the Executive Vice President and Company Secretary of ITC Limited from February 4, 2018. Mr. Singhi is a fellow member of the ICSI and is a law graduate. He has over 38 years of experience in corporate laws and governance related matters. Prior to appointment as company secretary, Mr. Singhi was the senior deputy secretary of ITC Limited. He has been the chairman of corporate governance committee of the Bengal Chamber of Commerce and Industry and co-chairman of the governance committee of the CII Eastern Region. Mr. Singhi is presently on the boards of some of the subsidiary companies of ITC Limited. In addition, he is a member of Secretary Standard Board of ICSI, as well as the legal subcommittee of Calcutta Club Limited. During the year 2021, Mr. Singhi was awarded the Governance Professional of the Year Award by the ICSI for his contribution towards adoption of effective governance processes in the company.
Congratulations to you, sir. Congratulations. Great.
Thank you.
Great.
Thank you.
Thanks, Mr. Singhi, for your time. We really respect your contribution. I'll request Mr. Singhi to say a few words on the topic, then Mr. Bala to say a few words on the topic and narrating what we have talked up till now, and then we can start the session.
Dipti, I think I will say a few things on the...
Yeah, better you summarize and then Mr. Singhi.
Yeah.
Sorry.
Thank you. Good morning to all of you. I have a great pleasure in welcoming you for today's session, which is actually the last session on PIT regulations. This is the fifth session consecutively we have been conducting for the last 1 month. For your information, I just summarize what we discussed so far. When we started the PIT regulation for the first time, somewhere on 13th of May, we deliberated on the various definitions, especially insider, connected persons, designated person, what is the unsensitive price information, and from the company's perspective, all those things we have actually gone through very much in the definition when we started the first session. And we also understood what is the importance of the price sensitive information which leads to the market, what is the damage is this, how important is this, how the regulation has been brought in the background, all those things also we discussed. Then the second session, when we started on 20th of May, I think we had the eminent faculty, Savitri Parekh, who joined in that seminar. We spent quite a good amount of time on structural database. If you all recall it, the SEBI, the regulators, they were not happy on the implementation of the structural database. There have been many ifs and buts, and people had a lot of things, whether it can be made in the still the Excel sheet and other format, etc., and other things are done. And again, we deliberated enough on structural database, what point of time, because people have interesting questions. This information is shared. How many times, so many entries are required to be made, one entry is to be made, what is the thing, what is the valuable, what point of time, all the things we discussed elaborately, and Savitri Parekh was kind enough to share the practicality on this particular issue we deliberated. Then we came to the third session. Third session, I think, joined by corporate law advisor, none other than Mr. Ranganathan, who was there. As you are all aware, the PIT regulation were made applicable for mutual funds. Because initially mutual funds were outside the purview of the PIT regulation, but later the mutual funds have been brought. Especially they insert the new regulation, regulation number 5, which was applicable to that. Mr. Ranganathan was really kind enough to make a presentation, present himself the various intricacies relating to the mutual funds on the PITS regulations. He has taken us on that. Then thereafter we moved to last week, which was joined by none other than Mr. Rajendra from CIPLA, and it was specifically on the code of conduct. I must appreciate there are lot of practical sharing has been done by this Mr. Rajendra from CIPLA, various issues, etc., where we have really learned a lot of things. Because for personally myself, although what you call the system-driven compliances is actually implemented where the connected persons complaints are taken care of by the system-driven. Yeah, most highlighting thing which has been actually brought out in the system-driven, if the account is actually in the joint holders name, if the first person is named as a connected person, then it takes care of it. But the first person is seemed to be a second person, that means a joint signatory, then system doesn't take care of it. There were issues which we actually discussed. And again, there are issues like, the connected person's daughter. He was thinking she is still young, but she grown enough and she opened account on her own and she opened the demat account. There was actually dealing done by her without the knowledge of the connected person, how the things were handled, etc. Those sort of things, it was a good learning actually for us last time when we discussed on this code of conduct. Then really it has given an inside idea in the code of conduct, what are the various things we have to take care of it, precautions we have to take care of it. All those things we have discussed elaborately on that. Basically, I think we talked about regulations 6, 7, and 8. That is what we talked about it on that. And today being the last session, we are basically going to talk mainly relating the code of conduct arising out of the various compliances which are actually required. That means this is the regulation 8, read with the schedule A, B, C. Schedule A talks about the code of conduct itself. Schedule B and C talk about the compliances which are relating to listed companies and also other intermediaries. That is what we are going to discuss elaborately on that. I think this session, last 5 sessions were really very useful. The number of attendees who are actually there in this session really shows what is the importance of this. Because in fact, one of the sessions, I think last session only, I think, Rajendra was asking, this particular seminar is recognized for the credit hours. That is the question he actually asked. Interestingly, because normally people attend the webinar and not to conduct the credit hours, etc. and other thing and all. When we told them this is not attended for the credit hours, it is only for the knowledge sharing session which has been conducted by Mehta and Mehta. And instead of discussing one particular session and topic, which is very limited thing, we actually pick up important topic which we deliberated threadbare about 4-5 sessions. That is what we talked to him. He was really overwhelmed to hear this, and especially the number of participants, even at the closing hours, which are around 160, that showed the importance of the topic. Really, I must actually be very grateful for the entire team of Mehta to bringing out such a nice topic and deliberating the issues, etc. and other thing and all. And I also more so thankful to the panelists who actually come to this seminar and they share the practical experience which keeps adding the knowledge. I think let us spread the knowledge, let us keep adding the knowledge. There is everywhere, there is a learning process there from both the sides. I also learned something, you also learn something. I always used to hear, suppose you have 1 rupee, I have 1 rupee. We exchange 1 rupee from each one of us. We don't become rich. Still, you continue to have 1 rupee, I continue to have 1 rupee. But on the other hand, if we have one idea, we exchange the idea. When we leave the platform, you are richer by 1 more idea, other person is richer by 1 more idea. That is the way the knowledge gets added here. I'm very thankful to the participants also for putting their views and expressing their, sharing their practical experience at time by the people also. Very nice. So with these few words, I'll ask Mr. Rajendra to speak on the topic a few words and before we start the session. Over to Mr. Rajendra, please.
Thank you, Professor. Good morning, everyone. At the outset, I'd like to thank Mehta and Mehta, and in particular, Sudhakar and Dipti for inviting me to this webinar. The SEBI Prevention of Insider Trading Regulation is a very pertinent and intense subject matter. And I definitely compliment Mehta and Mehta for organizing 5 webinars on the subject for an in-depth discussion and better understanding of the provisions of the law for all concerned. Well, coming to this regulation, see, regulation per se, the intent and principle of the regulation is that no connected are quite praiseworthy and is based on the principle, cardinal principle that no connected person in a listed entity should deal in the shares of that company on the basis of unpublished price-sensitive information. Well, the regulation per se does not prohibit trading in the shares of the company. It attempts to lay down certain checks and balances as to how you should deal with the, when you deal with the share, how you should go about it, kind of thing. However, there are certain issues which the corporates and the professional like us keeps on grappling with this particular regulation. The problems are some of the provisions, how do you interpret it? And how do you implement also in the absence of certain clarities? Just to say few examples, like what is insider trading per se, it has not been defined in the regulation. When information becomes an oopsie, it's not very clear. Consequently, when a trading window has to be closed, whether it should be closed for all or for certain set of people, and these are left to the all discretion of the compliance officer. And this problem becomes more onerous when a company like ITC, when we have a large 13 businesses which are very large, but the sword is always hanging on the compliance officer in the company for compliance with the requirements. Be as it may, but SEBI also at times takes a very impractical and I would say irrational views on certain provisions of this law, which are neither backed by the provisions of the law or nor it to the knowledge of the compliance officer. I'll just illustrate one anecdote which happened with us. Say about, as you all know, 3 years back, till 3 years back, there was a requirement that any employee of a company who deals in the shares of the company in excess of a value of rupees 10 lakh, then they were required to disclose to the company such dealing transactions, and the company in turn has to advise to the stock exchange within a period of 2 days. And the law is very clear that on receipt of such disclosure from the employee, company has to disclose to the stock exchange. So sometime in 20, SEBI issued a so-called notice on the ITC and on me for the alleged delay. Incidentally, before that, this person disclosed to the company about, I think, after 78 days, and the same day I have advised to the stock exchange. But SEBI came out with a so-called notice against me and the company for the alleged delay in disclosure of this information to the stock exchange, and they said why action should not be taken against us. And their contention was weekly BenPost data is already available with us. So you were aware of the information, so you should have disclosed when you have seen that. So we contended with SEBI that first and foremost, the law is very clear. The obligation is on the employee to advise the company, and then in turn only company can advise to the stock exchange. And number 2, BenPost is only a statement. It's not a transaction data. It just gives you a weekly position. And the purpose of BenPost is something different, not for insider trading regulation. So we contended, and then SEBI finally accepted our contention, and they said, yeah, you were right. It is not, BenPost is not the basis on which compliance officers should be disclosing the data to the company, and we were all clear. But the point is here, just because of this irrational approach, the time, effort, money of the corporates and us has gone into this. If SEBI could see a little bit, take a very practical, rational approach, it will help all of us. So there are many more such issues like that, but I'll leave it here. And as we go along, we'll deliberate on some of the other nuances of this regulation. Thank you.
Thank you very much, Rajendra. We are very
Uh,
thankful for sharing this particular experience.
Yes, yeah, it was
But,
very.
but one thing is very, very clear. This very clearly shows there is a great amount of awareness creation is required within the organization, informing the people what to do, when to do, what is the time limit, what is the important. That awareness is actually definitely corporate. Okay, that is the thing. So
Okay.
nice of you, sir.
Kanchan, you can start the presentation.
Yes, ma'am.
Thank you.
Good morning, everyone. I'd just like to make one announcement before we start. Request you all to please stay on mute whenever the presentation is going on. If you only have questions, please unmute yourself. It would not affect the flow of the presentation. So today's topic is, as our panelists have already said, it is the last in the series of PIT regulations. So we are going to deliberate on the code of conduct and the compliances under SEBI prohibition of insider trading regulations. So chapter 4 of PIT regulations, it deals with the codes, that is the code of fair disclosure and code of conduct. Yes, so the codes under PIT regulations, as we see here, Regulation 8 and Regulation 9 deal with the code of fair disclosure by the listed companies, as in the Regulation 8 Schedule A, and code of conduct by the listed companies is dealt with in Regulation 9 Schedule B. And Schedule C of Regulation 9 deals with the code of conduct for the intermediaries and the fiduciaries. So let's get into the regulations and the codes, what they exactly define. So Regulation 8, code of conduct, code of fair disclosure. So Regulation 8.1, it talks about the responsibility of the board of directors with regards to the code of fair disclosure. So it says that the board of directors of every company whose securities are listed on a stock exchange, they shall formulate and publish on the official website a code of practices and procedures for fair disclosure of UPSI, unpublished price sensitive information, that it would follow in order to adhere to each of the principles set out in Schedule A to these regulations without diluting the provisions of these regulations in any manner. So we would, in the flow of this presentation, we would get into the details of Schedule A, what it exactly talks about, but this is what Regulation 8.1 basically talks about. Regulation 8.2 is the requirement to intimate to stock exchanges. So every such code of practices and procedures for fair disclosure of UPSI and every amendment thereto shall be promptly intimated to the stock exchanges where the securities are listed. So maybe our panelists could throw some light on what exactly do we understand by promptly when we say the intimation should be going to the stock exchange.
So I put it this way, promptly means here the term promptly means as soon as possible. It is not that unlike that half an hour in the LODR regulation, we have certain income which has to be disclosed within half an hour or 24 hours and so on and so forth. But yeah, promptly as soon as practical, as soon as possible. That's the way I will look at it.
Right, sir.
Thank you. Yeah, Kanchan. Yes.
Yes. So to break it down, Regulation 8.1, the applicability of this code is on the board of directors and the chief investor relations officer, CIRO. And why do we have this regulation? It is to ensure the prompt and uniform disclosure of UPSI and avoid its selective disclosures. So as we have understood that the bare minimum requirements that should be adhered to are according to Schedule A of Regulation 8. And according to this, the intimation should go to the stock exchange regarding the code of fair disclosures and any kind of amendment as promptly as possible. And all of this needs to be disclosed on the website also of the company. So let's now get into the Schedule A, what it exactly talks about, the principles of fair disclosures. So it says there should be a prompt disclosure of UPSI, which could have an impact on price. And there must be uniform and equitable disclosure of UPSI to avoid any kind of selective disclosures. And for this purpose, we need to have a designated senior officer who must act as the Chief Investor Relations Officer to deal with this designation of UPSI. It is for appropriate and fair response mechanism to handle the market rumors, which could have any kind of impact on the price of the share. We must ensure that the analysts and the research personnel, they don't get the UPSI. To make the transcripts of meetings with the analysts available on the website of the company as early as possible, and to handle the information on need-to-know basis and the policy for determination of legitimate purposes.
So Kanchan, just to add on here, this Chief Investor Relations Officer, just to share our experience. So we have our CFO, who also happens to be a finance director. He is the person. So we give that kind of importance to this particular role.
Right, sir.
Okay, thanks.
So Code of Fair Disclosure, it gives on the board of directors a very important responsibility. Board of directors of the listed company, they have to formulate the Code of Fair Disclosure and also publish on the website the framework and policy of the events and the occurrences that could impact the price discovery. The principle of avoidance of selective disclosure and universal dissemination of information, that is the motto of the Code of Fair Disclosure. And like we had just, sir has mentioned, that the kind of importance that a senior officer, a designated officer carries is of the level of a CFO and somebody very senior person who must deal with the disclosures and the code of conduct. The process for handling and verification of the market rumors must be very carefully handled. And any kind of information that goes out to the analysts and the research personnel is not UPSI. This must be ensured.
Rajendra, if I am not mistaken, when you deal with analysts outside your organization, do you have any particular policies like, this can be done only by the designated people and the people cannot get in touch with any of the other organized offices,
Yes.
etc. and other things and all?
Yeah, we have an investor relation department who
Yeah.
deals with the institutional, etc., and going to the analyst meet, etc. So only these are the people with whom anybody can get in touch insofar as the analysts are concerned or institutional investors are concerned. So they will go. For other matters, etc., is our corporate communication department is there to deal with them. So they in turn get in touch with me and our legal counsel, if depending on the need, and then he will respond.
I see.
No other person will respond to this kind of things.
Sir, way back, I think maybe I'm old timer. Maybe 25 years back, when this regulation newly came, when we studied the in-depth regulation, I had an occasion to discuss with my board of directors what we have done that particular time. We have actually formulated the internal policy, dissemination of the market information by the designated people, not by the people. We made out the policy, we made it known. We have actually told who will deal, who will not deal, etc. That sort of thing. Even though the policy was not mandated by any of the regulators, we have done that. That is the purpose why I asked you.
No, we have also a policy just to take for even for any information in the company, everybody and anybody can't go to the press or can't go to the media and tell. There's a very clear laid out policy. Even our policy extends on the social media also, what you will write, what an employee can write, what he can't write. So it is very well documented. We have that policy.
Thank you. Yes, Kanchan.
Yes, sir. So coming to the regulation 9, which talks about the code of conduct. So this regulation can be understood in terms of 4 sub-regulations under it. So like 9.1 talks about the formulation of the code of conduct, and 9.2 talks about the code of conduct for any kind of fiduciaries. 9.3 would talk about the identification of the compliance officer, and 9.4 is the identification of the designated employees. So let's get into these regulations one by one. So as per regulation 9.1, every listed company and the board of directors or the heads of the organization of every intermediary shall ensure that the managing director or the chief executive officer of the company formulate a code of conduct with their approval to regulate, monitor, and report trading by its designated person or persons and their immediate relatives of the designated persons. So the board of directors of the listed company must ensure that the code shall conform to the standards set out in Schedule B of the regulations. So every listed company must ensure that the standards set out in Schedule B must be included in the code of conduct, and likewise in Schedule C in case of intermediary to these regulations, without diluting the provisions of these regulations in any manner. So maybe we could have a little deliberation on this query by the panelists, whether a separate code of conduct can be adopted for a listed company and each of the intermediaries in a group.
Well, my answer will be yes. You should have a separate code of conduct for listed company as well as their intermediary, because the requirement in for other companies could be a little different. Suppose it's the intermediaries, their requirement will be something different. And as far as the main company is concerned, their requirement will be a little different. So it should always be separate. It can't be combined. Fit for all size, it can't be.
Thank you. Yeah, Kanchan.
So code of conduct for listed company. Now this talks about the Schedule B. This is applicable on the designated persons and their immediate relatives. See, the onus of formulation of the code, like we just discussed in 9.1, it is on the CEO and MD. So the purpose is to regulate, monitor, and report the trading by the designated persons and their immediate relatives. Compliance officer must administer this code. So let's get into the nuances of this. What does it really require us to do? So there must be identification of the designated persons on the base of role and the function apart from the seniority. There must be a policy in relation to the access to UPSI on need to know basis, the Chinese wall procedures, how to bring the people inside. It also talks about the importance that the code gives to the position of a compliance officer, and how do we deal with the leaking of UPSI and the protection against victimization of the informants. And likewise, there must be a whistleblower mechanism that must be in place. It also talks about the thresholds and the formats for seeking the pre-clearances, reporting of the trades, initial disclosures, annual disclosures, and continual disclosures, and also the personal information which is to be put in. There are these important areas that we would, in the flow of this presentation, we'd understand the restrictions in relation to contra trade, what is the period of closure of trading window, and the maintenance of the restricted list, and also the penalties and reporting in case of contravention of the code. So maybe I would like to understand a little from our panelists here. We'll be talking about Chinese wall procedures, as in, we only have a set number of people who have the access to UPSI. So maybe could you throw some light on what basis do you bring the people inside for sharing of information from the panelists, if I may understand?
So what we do, we have it, for example, UPSI, beside the results, etc. Those are everybody knows those accounts team, etc. There are designated people, they are already designated employees, so window will be closed for those list of events. But there are a lot of things. At times, people keep on evaluating newer opportunity, inorganic growth here and there, etc. And since we have so many businesses, so it's become very difficult for the compliance officer to sit here and decide who should be brought into, because obviously all designated employees are not there. There will be some non-designated person will have to be brought in on the working, etc. So here, what we have done, number one, sitting here, we have created an SOP, which details out list when, how people will get into this, who will do what kind of thing. So if it is happening in a particular business, suppose some particular proposal is being evaluated kind of thing, and some guys have to brought in, then the head of that business has to write to us, me, and then that I, in consultation with the investor relations officer, and if required with the CEO, we discuss and we bring some persons in the insider into the Chinese wall kind of thing.
Right.
That's the process we follow.
Right.
See, Kanchan, in fact, there are two issues. One issue is, whenever you are talking, is a routine matter, as he rightly said. The routine matter is largely the financial result declarations. So all the people who are there, connected person, they are all there. We need to send a notification, etc., trading window closure, etc. It is applicable throughout to everybody. But in the specific circumstances, as he rightly put, Mr. Rajendra, certain new opportunities are being born, merger informations being done, or some sort of the things are there. All the people may not get connected. There will be only very selective people who will actually get connected. So that means there will be two set of people will be there. One is the larger people who are already there, the connected people. And here, the new set of people who are connected only for this limited purposes will be there. So in which case, what happens, even sometime, if you want to close the trading window, etc., and other thing and all, it may not, information may not go to all the people at a particular time, because everybody does not have this information. It might go only to the selected people who are actually identified freshly for this particular purposes. That also will be there actually in the organization.
But Professor, just to add on to this, now window closure, when you said, see what happens in a company like bigger companies, sometime or other you keep on evaluating certain proposals, and there is a strategic cell also centrally who also look at. So that becomes a very difficult question. If you keep window closure for those people throughout the year, then literally they are closed for throughout the year.
Correct.
And they are, in our company, we have a stock options scheme also. So they have the stock options which are given at a market price. So if window is closed throughout the year, then when they will sell the stock option to even buy. So that becomes a very, very tricky stuff. When do you actually close the window for certain employees at which stage? So this is there is a little subjective thing, So probably we have taken a stance. Now it could be right, it could be wrong, but we have taken, whenever we we sign a binding agreement, only then those who are involved, the window gets closed for them, not before that. Because otherwise it is impossible to.
Right.
I agree with you. Actually, this is going to be, like walking on the tight rope. Actually, in fact, it is purely based on the judgmental and taking the stock of the situation, when, what, etc. Because nowhere the regulator says what you should do. The company's discretion, absolutely. Because if they think yes, it is going to affect. Because the main important thing is that if it is leaked to the market, is it going to have impact on the market? That is the call the company has to take. It is really a situation the company has to exercise their discretion, take a call. Yeah.
So that call is also a problem. Market, how does it affect the securities? Now,
Correct.
How do you make out that this particular information will make the price goes up by say X percentage or goes down X percentage? It's very difficult. It can happen for something else. Like a large company, if I start buying today, there is something else happen. Market may go up on that particular date, may happen. So what we have taken a very subjective. Internally, we have said if it is expected to exceed by 10%, up or down.
Okay.
That the threshold we took, but again, that is also subjective. Even if after that, it may not go 10% also.
I agree.
In all growing companies, there is always some growth opportunity is always thought over. So it will be, as rightly mentioned, that then the window will be always closed. It can't
Always
be that.
That's the point.
Right. Yeah, Kanchan, go ahead.
Yes, ma'am. So the next regulation 9.2, as per this regulation, the board of directors or heads of organization of every other person who is required to handle the UPSI in the course of business operations shall formulate a code of conduct. So why is this code required? The UPSI flows from companies to fiduciaries and intermediaries. So there is all the more requirement to protect such information, which is to regulate, monitor, and report the trading by the designated persons and the immediate relatives towards achieving the compliance with regulations, adopting the minimum standards set out in Schedule B and Schedule C to these regulations without diluting the provisions of any of these regulations in any manner. So let's move ahead. 9.3 talks about identification of compliance officer. So as per this regulation, every listed company, intermediary, and other persons who are formulating the code of conduct, they must identify and designate a compliance officer who shall be responsible for the administration of code of conduct. So maybe our panelists here can throw some light on the importance of the compliance officer with regards to PIT regulations, and maybe some experience that they have.
All I can say, the buck stops at compliance officer. No matter what system, whatever it is there, it is your, you have to do it. And nothing else, kind of say. Okay,
Rightly said, rightly said.
So whatever you do, whatever, no matter how much systems, SOPs, etc. do, you put in place, but actually it comes here and the SEBI will ask you, and even internal management will say, why did not you do it if you know, if you have, and SEBI will say, why did you not do? So it's all subjective. As basically all good. To the best of our ability, we try to put systems, checks, balances in place, and then if I put it lightly, leave it to the God.
Yeah, please go ahead.
So the role of compliance officer, like sir has rightly said, the buck stops there. It has also been enumerated by SEBI in the informal guidance, even in the Kirloskar Chillers Private Limited. So according to this judgment, the compliance officer reports to the board of directors or chairman of the audit committee, as the case may be, and the compliance officer has the discretionary power to grant or reject any pre-clearances after necessary assessment of the PIT regulations and code of conduct. The compliance officer shall ensure compliance of insider trading regulations in letter, in spirit, and not with any ulterior motives.
So Kanchan, I'll just come in here just to say, like it says in that case, left to the discretion of compliance officer to accept or reject kind of thing. So to avoid that biasness, if I don't like you, perhaps I will not give you kind of thing. Maybe in the large organization, it happens like that. So in our case, along with the compliance officer, an executive director also has to approve that. So that at least there is some balancing is there kind of thing.
Thank you.
So regulation 9.4, which talks about identification of designated employees. So the amendment regulations 2018 has inserted a new regulation by virtue of which the board of directors or the heads of organization shall, in consultation with the compliance officer, determine who shall be the designated person in the organization covered by the code of conduct. So this is a pertinent case law with regards to designated persons. So in this particular case, Mr. X is currently holding a 13.34% shares of PQR Limited. He was earlier one of the promoters of the company. Since 2018, he is not acting as a promoter of the company, and he has no role in any decision making of the company and or any kind of access to the information pertaining to the business of the company. However, he cannot be classified as a public shareholder due to the provisions of LODR. So SEBI answered the following query: whether a person named as promoter pursuant to LODR but not acting as a promoter will be identified as non-designated promoter for regulation 9.4 of PIT regulations. So if this non-designated person executes the trade during trading window closure, whether it will amount to violation of clause 4 of Schedule B of PIT regulations. So the PIT regulations, they identify the promoters as designated persons. So a person identified as a promoter is required to comply with the code of conduct requirements as required by the other designated persons. So this Mr. X, by virtue of being named as the promoter and on account of continuing to hold more than 10% of the total voting rights in the company, shall be identified as a designated person for the purpose of compliance with the company's code of conduct. So let's get into the key terms, key matters under the code of conduct, Schedule B. Trading window closure, pre-clearance, and contra trade. So we would understand the concept here in depth. So closure of trading window. This is in two ways. It can be either periodical or event based. So in case of financial results, it is periodical. So trading window remains closed for at the time of declaration of the financial results, let's say at the quarter end, for 48 hours after declaration of results. So in case of any other UPSI, it's an event based, like dividend declaration, change in the capital structure, mergers, acquisitions, demergers, changes in the KMPs. So trading window, it shall remain closed from the point of time the UPSI is originated till the time the event is disclosed by the company publicly. So any comments from our panelists on trading window closure?
No, this is perfectly correct what you said actually. It's
Right,
there's nothing to add.
Right, sir. So moving ahead, we've got certain exceptions to the trades permitted during the window closure. So like off-market interstate transfer between the insiders who are in possession of the UPSI, the transactions executed through block deal mechanism between the insiders, or anything carried out pursuant to statutory or regulatory obligations, or pursuant to exercising of ESOPs where exercise price was predetermined, pledging of shares for raising of funds subject to pre-clearances given by compliance officer, and any kind of transactions such as acquisition by conversion of warrants or debentures, subscribing to rights issue, further public issue, preferential allotment, buybacks, delisting, transactions which are undertaken through any other mechanism as may be specified by the board. These are the exceptions to the trades permitted during the window closure. So maybe we could deliberate a little on these particular queries that we could possibly have. When should the trading window be closed by the company, and for how long can it continuously remain closed?
Yeah, as it was mentioned, like for example, the results, etc., the law itself very clearly said when it should be window should be closed and when it should be open. And so far the other events are concerned, for example, dividend, you said, the day you advise the stock exchange, from that date your window is closed and open after 48 hours the way. So 48 hours after is the principle which is followed everywhere. And insofar as some inorganic acquisition, etc., if those kind of things happens, then as I said, probably from the date you sign, appoint some banker, merchant bankers, or the day you those kind of, from that date it will be closed kind of thing. And of course, in our case, when this kind of merger, demerger kind of thing would happen, then we close the window for across the company, not only for designated person. Also, law doesn't require you to close it for the other non-designated person, but we close it for everybody. Just thought I'll mention.
No chance of any non-compliance. Better protect.
You want to be very extra careful.
Yeah,
No,
careful.
you don't want to take any chance at all.
True.
Yeah.
Yeah.
Yeah. Please go ahead.
So should the trading window be closed for every UPSI?
Now, this is the point where SEBI is also grappling, and they come out with the discussions. Obviously, if the trading window is closed for every UPSI, then no designated person will have any time to trade in the shares, and particularly people where there is a stock option schemes. So now this is a very, you have to see like Oopsie, for example, change of, your transfer agent. You don't need to, this is not an Oopsie in that sense, so that you have to trade, the window has to be closed. So there are many examples like that, where it is nothing to do with the Oopsie in real sense, means based on that, if there is likely to affect the securities of the market, but it may not be. For example, change of company secretary, KMP. I can understand the managing director or CEO, but company secretary change, why the window should be closed? He is a KMP. Just because he is a KMP, window should be closed. And my answer, in my no, it should not be. So
even if it comes to the KMP, again, as you rightly say, you have to actually exercise your discretion, because the expertise person who's occupied the position of MD, who's worked for the company, etc., the market is doing very well. Suddenly his departure will impact the market, then it becomes upset. As you rightly put in the company secretary, it will not. So you have to take a call there actually, but generally what happens is the sudden departure of the CEO, that is MD and the CFO, happens in a company. It has got the great impact because people think something is not right in the company. Yeah.
And like you rightly said, sir, if we start closing for every upsee, then the whole year around, it will remain closed that way.
Nobody can trade. That is
as it is closed for almost close to 6 months, because the quarterly results are close to those people. So even balance 6 months maybe also, then you will be closed all through.
And then I think the kind of stance that you have taken, that it will remain closed for everyone, then, I mean,
no.
There's nothing that can be done at all.
Let me clarify, not for the window closer for trading financial results, standard ones, it is only for the designated person. But this kind of big activity like some mergers, a demerger, those kind of things, we close it for everybody. Not for all the event, not for all. No.
Right. Okay.
So if the compliance officer fails to close the trading window, but no one in possession of upsee has traded, is this still a violation in your view?
Yes.
Yes, of course it is. It
is, of course.
So moving on to pre-clearance of trade. So the designated persons and their immediate relatives, they cannot trade when the trading window is closed. When it is open, the trade by the designated persons shall be subject to the pre-clearances by compliance officer. Company may develop its own threshold for pre-clearance. For example, if the trade of 1,000 equity shares or trade of 50,000 rupees or more shall require pre-clearance. Compliance officer has to seek declarations before granting pre-clearance that the person is not in possession of upsee. Also has to analyze whether such declaration can be capable of being rendered inaccurate. So application for the pre-clearance, one needs to obtain the approval and the trade needs to be executed in 7 trading days. And such kind of trade needs to get reported to the compliance officer. And if the approval is given and the trade is not executed in the next 7 trading days, then one needs to again apply afresh. And when there is no pre-clearance given, then no trade can be executed. So that's the kind of power that the compliance officer holds in terms of giving pre-clearances for trade.
I would like to add a couple of things here.
Yes,
From practical experience. For example, in our company, number one, we have prohibited derivative trading in ITC for across all the employees. Sorry, designated employees. They can't deal in the derivatives. Number one. Number two, those who are optionees, those who have been given stock options, they can't buy from the market. It's banned. As long as they are holding options, they will not be able to buy. They can only sell in the market. Just to avoid, otherwise there is a tendency for people to do trading. Okay, today is sold at 500, again tomorrow it is going down at 480, then I'll buy back and all that. So they will be indulged into this kind of thing. And then those designated employees who do not have options, we have made a limit of 10,000 shares trading in a quarter. When either you buy or sell, combination cannot go more than 10,000. So these are the little things we have taken just to control that, at least. Otherwise, large company, there could be somebody will be dealing in the accused of insider trading, etc. So these are the additional steps we have taken.
Right.
There is one question, whether trading window should be required to be closed if all non-promoted directors, that is independent director and professional director, resign at once.
Yeah, that probably, but by the time they resign, see, whenever it happens, they resign and you get to know, you have to advise stock exchanges. So in any case, the matter becomes public. So how you will, what is the purpose of closing the window?
Yeah, because you have to immediately intimate.
Immediately have to advise the stock exchange with the details of resignation, etc. I can't be holding on to the resignation letters of IDs. So
Right.
the moment it comes, I need to advise.
Because the information become public. So if the information is public, there is no question of, closing the trading window, etc.
Yeah.
There's one more question is actually asked here. Does it in practical case,
That we will not take.
compliance officer who's an
It's not
employee,
question, not necessarily taken,
Yeah.
whether we can practically oppose management, it's a practical situation. There is another question is, apart from specified UPSI, other UPSI which may impact price of security, for such UPSI, do we need to close trading window for DPs? Whether such closure is required to be intimated to stock exchange?
The other UPSIs, it has to be linked with the materiality also. Like, in a certain thing, if a company, small size company, if you have bagged an order of say 1,000 crore or something, or you are going to lose a particular case in a company, depending. So it has to be linked with the materiality. So you have to see that judgment has to be made at that point that this UPSI actually, will it impact, how it will impact, or large company, because large company, even if I take a 10% threshold,
It's a
so
big.
if it goes, we take it at 10% threshold. If it 10%, more than 10%, it is going to affect my turnover, profit, production, etc. Then I will. Otherwise, I will not advise. So
Yeah.
I would say it should be linked with the materiality also.
Materiality, yeah, okay.
Dipti, ultimately, the acid test is what is the impact it is going to have in the marketplace by this. That is what it is. Again, I see rightly put, yes, said they are taken 10% threshold, etc. Company has to actually decide that and they'll have to go. Ultimately, the impact, that is what it matters.
Right.
Yes, Kanchan.
So there are a few questions here as to who would approve the trades by compliance officer or his immediate relatives as insiders.
So it has to be the managing director.
Managing director.
Right.
Yeah.
So can a MD trade in its own company's shares with pre-clearance alone, or a trading plan is necessary?
No, it can be. He's also like an employee. Even a professional company is also an employee. Why? And if he's got the stock option, why he can't sell when the window is open? But what we do yet, so we have a threshold. Within the threshold, he can also sell. But beyond the threshold, if he has to also sell something pre-clearance required, then the compliance officer and executive director will, and another executive director will approve this.
Right. So moving on, what is the position of compliance officer if a designated person gives an undertaking for not possessing the UPSI and then trades, but eventually it comes to light that he possessed the UPSI? So what then happens to the compliance officer, because he is supposed to take care of this?
Then a compliance officer can't be. He is given a declaration, so this guy should be penalized. So one is internally as well as externally. Whatever the case has to be.
Compliance officer is concerned, he can only exercise and he can only ask, and he goes by the declaration what he has actually received. Because he doesn't have anything, a declaration is a false declaration, and he is not asking a police officer saying what the declaration is given, he is actually relieved from his. If this person is deliberately done, yes, SEBI will definitely take action against him. That is one. Second thing is, of course, the company also will take internally the action.
Yeah, company will also take action against him.
Right. So moving on to the concept of contra trade. So let's say Mr. X has purchased shares, 1,000 shares from open market. The transaction executed on, let's say, 1st of May 2023 from Mr. Y. And then he's also made another transaction which will be proposed to be executed on, let's say, 18th of September for purchase of 560 shares from open market from Mr. Z. So this concept of contra trade is not allowed under the PIT regulations. So the designated persons cannot execute contra trade or opposite transaction of buying and selling both within a time frame of 6 months for the next 6 months. The compliance officer may grant relaxation from the strict application of contra trade restriction, subject to the condition that it is not against the provisions of these regulations. So the exception to the contra trade is any kind of trade which is pursuant to exercise of stock options.
What happens if he has already given the trading plan, which includes the contra trade?
I thought once you have given a trading plan, then this is already public. And you have given to stock exchange also. So I don't think this will have a problem if you give in a trading plan.
No, that is right. But the only thing is at the time of giving the trading plan, if the contra trading is there, I think probably before approving the trading plan, I think some sort of the exercise of diligence is required at that point of time. That's what I think so.
No, but at the time of trading plan giving, he doesn't know why he is doing the contra plan, not on the basis of certain information. He has bought, he has sold, he doesn't know. Today, contra-attainment person does maybe with the intent of making some money out of it. But when you're giving trading plan in advance, he is not aware of. So probably in the companies where purchase, sale, both are allowed. And maybe we can consider it further, but in my view, that should be allowed. That should be okay.
Yeah, no, I agree with you. The trading plan is approved, then there is no question. But the only thing is,
I should not be stopping them from in the trading plan itself if the contra trade is there. That's what I'm saying.
Okay.
Okay, there is another question. Gift of shares is trade.
Gift of share is, in our case, we have prohibited gifting of share during closure of trading window. We don't do this.
Okay, better avoid that. So
because even I can give to my, say for example, my children or some other person I've gifted, so as to say, on the basis of certain information. I can't sell, etc. But I've given it. Now this guy can do whatever he has to sell. And later on I can always buy or something, I can work it out. So to avoid this, we have said during closure of trading, no gifting will be allowed.
It's subjective. It will be tantamount that a clear motive or intention can be more. Yeah, thanks. Yeah, Kanchan.
Is the restriction on execution of contra trade in securities applicable in case of buybacks, open offers, and FPOs by listed companies?
Yeah, answer is yes. Any action you take, the person takes, is covered under this contra trade. If something which is not in your thing, then it will not be. But here everything buyback offers. Say for example, I know buyback, I will buy from the market first and then give it to the company. I'm aware of. Open offers, I'm aware, I can buy the share from the market, then I'll give it. So these are all in my trade. Any action taken by the person in all this, what you are saying is that action has to be taken by the person. So he must have bought something else in anticipation that the buyback is happening. I'll surrender this share there and make a money. So contra trade will be applicable.
Right. Is contra trade restriction only applicable to trades under pre-clearance or on any transaction, even if the trading does not exceed the threshold limit?
I thought contra trade is applicable in all transactions.
Right.
There is a comment for participant that short delivery of share of a purchase trade subsequent to disclosure will be treated as contra trade, from Mr. Pradeep Oja. Yeah.
Yeah. So the contra trade restrictions by designated persons is applicable only in respect of the listed company's own securities or for all listed securities?
This will be for your own security.
Only own security. No, how can be across? It cannot be universal. It is only particular reference to the company, no?
As long as the UPSI is not there with the person, then we are good to go.
Yeah.
Yeah.
Right. So moving on to Regulation 9A, which talks about the institutional mechanism for prevention of insider trading. So as we see that there are 7 regulations under it, which we would get into one by one. So we would talk about the practical aspects of the 9A and not directly deal with the regulations as such. So there must be a policy for leak of UPSI. So for this, we need to identify the source of leakage of UPSI. And there must be a procedure or a mechanism to initiate the inquiry in case of any leak of UPSI or a suspected leak of UPSI should be provided. And then the authorizing audit committee or SRC is to take the necessary steps against the person who is found guilty and to plug the loopholes in the internal control system in order to prevent the leak of UPSI in the future. And there's also a need to educate and sensitize the employees regarding the reporting of leak and suspected leak of UPSI and taking action against the person who's responsible for the leak of UPSI and informing SEBI promptly of such leaks.
I think, Rajendra, you may be having a standard operating procedure for this also in your organization, I believe.
Yes, we do. And generally, whenever any leak, of course, first of all, we didn't have any instance of leakage, so I don't have any practical experience of how to deal with leaks. Number one. Number two, of course, we have a policy, we have an SOP. And in terms of SOP, if suppose something of this sort happen, then the head of legal, head of CFO and the company secretary generally is a committee, and they will investigate the matter and then they'll report it to the audit committee and the board as it requires.
So maybe could you throw some light on any kind of training programs that are conducted?
What we do, we from time to time, we send flyers to all the employees. What are your do's and don'ts with respect to not only in respect of tradings, etc. When do you, how much is your limit, etc. Even on these kind of thing, and deal with read with this also the whistleblower, which is also in a manner linked. So we keep on advising people from time to time the flyers on this with a little more user-friendly format. Let me put it this way, in a flow chart form or something, so that we keep on doing kind of thing.
Okay. Yeah.
Great, sir. That means you are continuously, spreading the awareness of the people, what to do, what not to do.
No,
Great.
that every quarter we send one.
Okay. Yeah.
Moving on to handling of UPSI on need to know basis. So UPSI should be disclosed only to those within the company who need the information to discharge their duties. The company should develop a practice on need to know principles, which shall include that UPSI can be shared only on need to know basis and it shall be used only by the person who is so authorized. The confidentiality must be maintained at all times. And for this, you could also have an execution of an NDA with the person with whom the UPSI is shared. And there should not be any kind of conflict of interest. And the compliance officer should be reported about sharing of such information. So there's a standardized reporting format for code of conduct violations. SEBI came out with a circular in 2019, 19th of July, which requires the companies to record any kind of lapses or violations under PIT regulations in digital database. So it provides a standard format for reporting of the insider trading lapses. Earlier, companies followed diverse practices and reporting in many cases was informal and self-generated, which was later modified by the format which was provided in 2020. Just to give you a brief of the standardized reporting format, it must be dealt with in this way. This is the format for disclosure. So moving on.
1 minute. Kanchan, there is a question.
Yes.
From Rupal Narvekar. Dear sir, so contra trade is applicable to all PP throughout the year as it has nothing to do with trading window closure. And since there is no limit on shares, so even in the single share is prohibited for contra trade. Am I getting it right?
Yes, unfortunately, yes.
Yes, the situation is the same. As you rightly say, it is correct.
So it's a prohibited. Okay. Yeah, Kanchan.
So in the matter of Edelweiss Financial Services Limited, there was a penalty of 5 lakhs that was levied on the compliance officer for default in the closure of trading window for material information mentioned in Regulation 30 of LODR. So as per this, the existing provisions of law, every material information as per LODR was a price sensitive information as per the PIT regulations, also consequently warranting a closure of trading window. So the practice of merely making the relevant employees cognizant of their responsibilities doesn't tantamount to closure of trading window as has been expected in the law. So this was one pertinent case law with regards to the trading window closure.
That was
Now,
also pertaining to the timing of the initiation of the document on that particular event, So I think the exact person or whatever, but I think here it is more to do with like what Rajendra sir said. What document triggers the real binding, and then we need to be informed. So I think in this case, the compliance officer said that it was not very sure that it is going to be a binding document, So and hence it was not informed as part of the regulatory. But it's better to be in compliance when you are in doubt. Sometimes it is
right.
Better to be safe than sorry.
Absolutely. So moving on, let's talk about internal control as per the PIT regulations. Who are responsible for internal control? So the CEO, managing director, or any other person as designated by the board are responsible for establishing adequate and effective systems of internal control. And then the audit committee has to review at least once a year a compliance of PIT regulations, verify the internal control mechanisms, whether they are adequate and they are operating effectively. Here it is also important for us to understand the concept of whistleblower. The whistleblower mechanism of the company should also sensitize the employees to report the instances for any leak of UPSI. The mechanism should mention that employees can directly report to the audit committee in case of any leak. The process for obtaining information of leak of UPSI must be enunciated clearly with this concept of whistleblower mechanism that must be understood by the employees. And any kind of disciplinary actions to be taken by the company in case of such leak by the person should also be clearly understood by the employees. Any comments from our panelists on the whistleblower mechanism or their past experiences, if they could share?
I'll talk on the internal control, how responsible. Okay, you make, although law says CEO, but poor guy, he has a lot of other things to do then rather than setting this systems and control. So basically it is the compliance officer's job to lay down all the systems, control, document it. And of course, you have to take him through, and then in case he has any input, further input, to take it and then fine tune it further. So what we do in a year, obviously audit committee ko, I put a report laying down all the control mechanism, whatever we have and how it is effective with examples. Also, we give it to them, and to the board also we give once a year a report, whether how the systems are working it out. And that report is signed by the MD and me. We two sign, compliance officers, the MD sign and put the report to the board. And the board has any questions, any suggestion, etc., that we take it on board, kind of thing. And that's how it works.
Right, sir.
And also in a year, every 2 years, we have a very strong internal audit department also. So they will also go through, we ask them to go through these systems, whatever we have here, is any leakage are there, they think this should be strengthened further by taking certain actions. So that are also taken on board.
Okay. Yeah, Kanchan.
So the institutional mechanism for prevention of insider trading, like we just discussed, CEO, MD, and any other designated person of the listed entity, intermediary, or a fiduciary are responsible for ensuring the effective system of internal control. Some of the important internal checkpoints that one needs to take care of is all employees who have access to UPSI are to be identified as designated persons. UPSI is identified and kept confidential by the company. Adequate restrictions on communication or procurement of UPSI. List of all the employees or other persons with whom UPSI is shared shall be maintained and confidentiality agreements shall be signed. Periodic process of review of effectiveness of internal control. Like Sir has just mentioned, that from time to time, it is important to check whether the internal control mechanism is effective or if there are any kind of further things that need to be taken care of. So here we must just understand the role of MD and the CEO in formulating the code of conduct to regulate, monitor, and report the trading by the designated persons, and ensure adequate and effective internal control systems are devised to ensure prevention of insider trading and to report to the audit committee and board of directors. They have a very crucial role to play under these PIT regulations. And then moving on, role of board of directors. So they need to designate a compliance officer and specify the designated persons for the purpose of these regulations, formulate the code of fair disclosure of UPSI, including the policy for determining legitimate purpose, ensure that the code of conduct to regulate, monitor, and trade by the DPs and their immediate relatives is formulated by the CEO or MD, approve such policy and procedure for inquiry in case of leak of UPSI and for determining the legitimate purpose, and that the information is shared only for the legitimate purpose, ensure structured digital databases maintained, and direct parties to execute agreements for maintaining confidentiality, non-disclosure obligations, specify the DPs in consultation with the compliance officer, stipulate the thresholds and the formats for pre-clearance. So there's a lot of importance that the role of board under the PIT regulations. Moving on to the role of audit committee, they must review the compliance with the provisions of the regulations at least once in the financial year. They must verify adequacy and effectiveness of the systems for internal control and suggest the measures to strengthen the same. The chairman of audit committee is to receive the reports from compliance officer at least once a year and ensure that the gap between clearance of accounts by the audit committee and board meeting is as narrow as possible, and preferably on the same day to avoid any kind of leakage of material information. So this was all about the codes, regulation 8, 9, and 9A.
So one question has come here. I think company has surplus fund and management would like to give the fund in the form of the inter-corporate loan to another group company that is a related corporate for its corporate use under section 186 of the Companies Act. So that means he is talking about related party transaction. And then he is saying, SEBI regulation whether compliance officers should close the trading window for this particular purpose. That's what is the question he is asking. Trading window should be closed, and approval of such a proposal, the audit committee, board, and should be treated as a UPSI for the purpose of PIT regulations.
But this is a normal routine course of business. Why?
I think giving a loan is actually attract only the related party transaction. That's all, nothing beyond that.
Correct.
Complaints regarding to the related party transactions to be complied with. this is no way is going to be attracting the price sensitive information at all, in my opinion.
Yeah, I agree with you.
Okay. Any more questions, participants? If it is, you can unmute and also say now since the session is over. If any question is there, we make the session open to, you can unmute and ask the question yourself also if you want. Okay, I think there is no questions. Everyone is.
Hello.
Yeah.
Yes, please.
Yes, myself Paresh Rayani. So I have one question regarding UPSI. So as well, we all are aware about the SDD compliance, the system-driven disclosure and maintenance of the digital database. That for UPSI, SDD should be maintained. But SDD said that it is to be maintained for the company which are proposed to be listed. But SDD PIT regulation says for maintaining SDD, if there is any UPSI which affect the, what is UPSI means, affect the price of the securities. But in unlisted companies, if any information passes one person to another, how it affects the price of the security and how it can be said UPSI for noting in the SDD compliance. Hope my question is clear.
Yeah, you are telling that if the company is not listed, then how you analyze that whether this information is affecting the price of securities of your
Yes,
company?
yes.
Rajendra, you will like to comment?
No, actually, I'm not very clear with the question, to be very honest.
Yeah, I think I'm also not very clear about the question.
Can you repeat it?
Yes. Sir, if I say that the PIT regulation says maintaining of SDD database, system-driven disclosure database, for recording the transfer or sharing of the UPSI.
Okay.
But SDD circular also saying that the SDD should be maintained for the companies which are not listed but proposed to be listed.
Okay.
If I am saying my company is in the process of listing, but in which company which is not listed, how UPSI gets generated in that company? What is UPSI? Which affect? If we analyze the definition of UPSI means the information which, if published, affects the price of the securities. But in unlisted company, if any information leaks, how it affects the price of the securities?
Okay, I got your point. I'll tell you. See, suppose there's a listed company. It like to acquire an unlisted company. Okay, the acquisition is going to be by a listed company with an unlisted company. Let us see that. If that is the case, so once the acquisition actually gets through, the price of the listed company share will actually get affected. That is number one. Number two, if you are actually talking about the acquisition, there will be people in the unlisted company who will actually definitely know this sort of the prices, etc., and all these things. Since they know this is what it is going to happen, since this information is going to affect the market price of the listed company, they can misuse this information. Are you getting it? What I'm saying?
No, sir, but my question about the unlisted company, which is in the process of listing, how that company can maintain the database of SDD, but which information can be identified as UPSI in unlisted company?
Shall I come here? I'm Kumar.
Yes, please. Yes, please.
So the problem arises from the provisions where, you know, the provision is under sub-regulation 5, where the mandate is to maintain the SDD by a company which is proposed to be listed. But it does not specify what is the role of the SDD in such company. So I am also facing this particular dilemma wherein my company is also now going to be listed, but I do not know, even if I were to maintain SDD, what do I enter there? What is the UPSI in my company? So I do not know what do I enter. Should I enter my own company's just the sharing of the financial results from in the finance department from one person to another person? Does it really make it UPSI because my shares are not listed? Then it is not an UPSI. If it is not an UPSI, then why I'm maintaining the SDD? That's the problem.
My question is the same, sir.
If now my view, I'm just putting that your shares are going to be listed on the stock exchange, and at present you are in the process of listing. So when you are fixing, you are going for listing, you must have valued your shares and your company.
But that all
I
information
know, I
are
know,
publicly
definitely.
available, right?
Yeah. It is publicly available.
Yes.
But anything which affects this, again, my view is we have to, because law is law, and we have to comply. So anything which affects the valuation of your shares can be treated as the information, according to my view, because since there is no, clear-cut guidance or criteria or a kind of thing.
It's because dilemma is that if any information which is going to be affect the price of the security or valuation or the IPO price, but IPO price comes only after the filing of the prospectus or red herring prospectus, whatever may be. Then there is information already available with the public. Then how it can be a UPSI?
But this information, if is anything event is happening which is going to change or kind of thing, because you are in the process of that.
Yes.
That, because your shares also internally you may be transferring
Yes.
before getting listed.
Yes, but price of the security gets discovered only company gets listed.
Yeah, of course. From the public, that
If it affect the price of the security, that is only after the listing.
not price. I will say valuation. I think.
Yes, whatever.
Because price will be discovered only after the listing. Please view one I put. I don't know, Rajendra and Bala, if you want.
Yeah, I think more it to do with the, he's right on one point, obviously, what is the UPSI, where they know UPSI, what I will do, but it is more historical data. Tomorrow, if they find something, once the shares get listed, with the conduct of those people to whom you're given, they may be knowing little more than what is to the public, etc. Based on that, if something after the shares are listed, if they do, and they need to look at the data, who has done, etc., all details are there. So maybe probably for the historical purpose, they want to have this data.
Okay, sir. Thank you.
Anyone else?
Sir, I just I'm agreeing with Rajendra sir. I was just trying to say this for this question. The section is the regulation is requiring to put historical data in place so that if any investigation after the listing of the securities are being done, then those historical data will be asked by stock exchanges or SEBI to relate the valuation and listing of the company.
Yeah, what you are saying is, it sounds very logical actually.
Yes, sir.
Yeah, anyone else, please? If it is.
Sir, but actually, the law is really not very clear. Now, in an unlisted company, whom do we designate as designated persons? How the UPSI flows from one person to another person? I think if the SEBI has prescribed maintenance of SDD by unlisted company, which is now say proposed to be listed, I think it is in the fairness of things that SEBI also should prescribe then that how that SDD should be maintained and when it should be maintained and what information should be entered in this. Without just prescribing all these things, simply it is saying that you should maintain SDD.
Mr. Rajkumar, I'll tend to differ with you on this. If you're going to be listed, it's better you follow all the provisions in the spirit and the law and take those, what are they said, who should be the designated employee, how SDD is maintained for listed entity, you should be maintaining in that way. So you are preparing for that going forward.
It is more of the futuristic rather than the looking into the current. That's what I would also think.
Yeah, but there are so many practical.
Sir, actually, when we are going to be listed, we hire so much consultants and valuers and all these things, and data informations are flows from a company to those consultants, and the company tries to sign NDA with those consultants. So why these companies are having NDA with those consultants, so that the informations which are very sensitive do not get flow from there to outside world before listing. So this SDD, I think, is required for those informations which are flowing from the company to consultant or merchant bankers and all those, which will be required to be investigated if SEBI finds anything wrong after listing. This is my assumption.
See, I just wanted to just add, sir, Rajendra ji has what mentioned. See, being as a company secretary, when you are holding a board meeting or shareholder meeting, you always have there are different kind of stages where you have to see pre-shareholder meeting, during the shareholder meeting, and post-shareholder meeting. So in the same way, when you are going for the listing, the public or small investors are going to make investment in your securities, it is expected that you are going to have a all those conditions which are required for the listed company. And part of the corporate governance, these things, the stock exchanges, they wanted that once you are going that for the public listing, then you are assumed that you are already following those things. And in any case, Rajendra has mentioned that these things brings a more corporate discipline. So it is also expected, if we start working on the border of the laws, then sometime we may end up in a difficult situation. Ultimately, the promoters lose the reputation in the market. So we as a professional, we always make sure that it's not that if riders and some definition of provided, if we use and say take, no. But the stock exchange are very clear. Why UPSI? UPSI is also only because of that where the corporates, they are going to have a completely values, business ethics. This is the core requirement for the corporates. So I feel that we must inform to our employees, our team, our valuers and bankers and institutions who are involved in the listing process. They should make sure that
Mr.
these things are
Suresh,
my
we clearly understand what you're trying to convey here.
Yeah, and there is a view from Ms. Rupal. As per my view, like listed company, anything which is likely to affect the prices of shares, you should consider all the events because it's going to be listed soon. The same view everyone is presenting. So if anything, yeah, Mr. Suresh.
It is a secondary part that whether it will help in investigation process or some queries raised by the stock exchange or regulator. But see, promoters' reputation, we should not forget. This is very important in the capital market.
We agree with you, Mr. Suresh. If anyone else there, then otherwise we'll close the session, please.
Hi, good afternoon. This is Purnima. Can you able to hear?
Yes, very much. Go ahead.
So actually, if any meeting is planned with the investors, with a few of the shareholders, in that case, do we need to close the window? We need to inform to the stock exchange if there is an investor made. Do we need to inform to the stock that is? We need to close the window?
So today it is not required. You don't have to close the window, but you have to follow that you don't disclose anything which is not available to the public at large in those investors meet. But you don't have to close the window. You need to advise the stock exchanges. That's the law as it is today. But tomorrow I don't know if that SEBI is that proposal.
No, some things maybe some information would have been passed to the shareholders so that we are acknowledging that no UPS has been shared.
As long as you make sure no UPS is shared.
Yeah.
There's one more question has
one question is not, I think Rajendra was talking. Or you finished, Rajendra?
I finished.
One more question has come. Also, there is no clarity about the proposed listed company because at what stage it should be set as proposed to be listed. When we consider from the date of passing the resolution, filing of DRHP or appointment lead manager, etc. Because IPO plans many times takes a long time or subsequently gets postponed also.
I will say the day you appoint formally your merchant banker to initiate works on that day it kicks in.
Yeah.
Yeah,
It's
I
a
agree with you.
concrete step. Yeah, I agree. Yeah. Anyone else? I think it's time now. We can close the session. No question is anymore. Thanks, Mr. Rajendra, for your time. Thanks for
Thank
your
you.
valuable input, sharing your experience. It
Thank
was
you.
wonderful to learn from you a lot. Thanks a lot. Thanks, Mr. Bala, for your
Thank you,
input.
Rajendra Bhai.
Thank you. Thank you.
Sorry, just late to join, but anyway. I was occupied.
Welcome you, Atul Mehta, for just in time for closing.
Thanks, Kanchan, for your wonderful
Yeah,
presentation.
Kanchan, you have done a wonderful job, really speaking.
Yeah.
And
putting
you
out
are putting
everything in a
googling
nice way.
question in between.
Yeah, I liked it very much because you actually kept everybody awake. throughout the session.
And thanks, entire participants. Keep on interacting with this way and keep on giving more insight into the subject. Thanks, Mr. Rajendra. You would like to say something?
No, thank you. It was even I learned a lot here. See, her presentation was excellent actually. It has gone into very
Thank you,
detailed, which normally I would not have gone in my job because there's a team who will look into it that way. So I
Yeah.
also learned myself also a little bit more today.
Thank
No, really, Kanchan has done her homework very nicely and put the things greatly. And not
Thank you,
only
sir.
that, her flow of talk with the lucid language, etc. and all, it was excellent, really. I appreciate Kanchan very much.
Thank you so much, sir.
Thanks, everyone. Thank you.
Thank you.
Let's
Thank
meet
you.
next week.
Thank you, everyone. Thank you.
Thanks a lot. Enjoy your weekend. Let us meet
Thank
yet
you.
another session. Thank you.
Bye.
Thank
Bye.
you.
Bye.
Bye.